So I beg to move that the total provision of rupees 177 crore 30 lakhs 23,000 under grant number 4, major heads 2014, administration of justice at page 2742 of budget be reduced to rupees 1. That is the amount of the whole grant of rupees 177 crore 30 lakhs 23,000 do stand reduced to rupees 1 to discuss the style and functioning of the law department.
Now you may initiate your discussion.
So, at the outset, I would like to thank you for giving me this opportunity. And in fact, I would also like to thank the Chief Minister for his elaborative reply on the budget. So, had we not raised the issue of loans and debts in this August House, I believe that the Chief Minister would not have taken a pain to reply on that day on loans and debts, where maximum of time he spent on that day was on loans, on debts. However, sir, I feel that Honorable Chief Minister still missed the opportunity. When we raise a genuine concern, sir, that cannot be termed as a misconception. Sir, it's very unfortunate that when we raise our genuine concern, is being termed as misconception. It is either an ill conception or misconception on our part. So as members of this August House, we are drawn, and our attention has been drawn by the figures that the government has declared officially in the budget document. So when we raise the issue of debts, it is not a misconception, sir. So here, I just want to put the record straight. It is reflected in this budget document, page 12, in this budget at a glance, sir. It indicates about the liabilities of state government as on 31st March 2018 to 31st March 2023. So the increase, and I'm very particular on the day, I choose to speak on the loan from the open market, which has increased up to 127% from 2018-2019 to 2024-2025. And in page 37, it has indicated the trend where the government is repaying these loans. So in column 2, on this page, sir, as I have expressed on that day, sir, this is just to put the record straight.
Point of order, Mr. Speaker, sir.
Yeah.
Point of order, Mr. Speaker, sir. As Rule 300. Sir, I don't know the honourable mover. When he moved the court motion, he referred to the budget speech. I think, as you rightly mentioned about the subject, where you said dwell upon this court motion itself, and that is the style and functioning of law department. I fail to understand, sir, why should the honourable member will take this subject outside this original court motion where he himself moved.
So, yes, since we are discussing about the budget, sir, I just feel that we need to put the record straight. As members, as responsible members of this August House, we are not having any misconception. Our serious concern, genuine concern, cannot be treated as misconception, sir. That is a very wrong message. So I just want to put the record straight, sir. So I request all the honourable members belonging to the Treasury to read this budget document. So coming to my cut motion. So when we talk about the word law, we understand that it means rules and regulations that govern the state and its people. So in order to ensure that the state or the country, for that matter, is free from any chaotic situation, laws are required to be made through a process of legislation. So law is a system or a method that disciplined and tamed human behaviors and actions. Therefore, laws are made to be respected and followed strictly so by all concerned. Hence, the law department, so I strongly feel, is a very important department in the government, as it provides legal advices on legal matters to the government. Therefore, sir, I feel that law department needs to be equipped with expert on legal matters, as it shall help the government to take right decisions. So as of now, I don't know how many cases that the government have won so far. History has revealed that the state government is very poor in dealing with cases. So, sir, I strongly feel that the selection of the Advocate General, whose role is very crucial, so should be done based on merits and expertise, not on connections or relations, sir. So it would be advisable for the state government to engage the best of legal experts in the departments to ensure that it escapes from judicial scrutiny on any important decisions or legislations relating to constitutional interpretation. So, another concern that I would like to raise in this August House is regarding the kind of assistance that the government needs to provide for common citizens in the state who have to fight for justice in the judiciary. So we know that the majority of people are ignorant about the law. Therefore, it would be prudent on the part of the government to engage lawyers so that the government can extend assistance to the common man. So because we know that the common people cannot afford to hire professional lawyer to defend their cases. Therefore, sir, I feel that the government should increase the number of government empaneled lawyers to assist such cases. Since the fees charged by the lawyers in these days are too expensive, sir, this will also protect the common citizens from being exploited. So, another point that I would like to raise in this court motion is the intention of the government to remove Justice Katakey. So according to media reports, the state government has deliberated on the idea of terminating the services of Justice retired BP Katakey, who is heading the one-man committee appointed by the High Court of Meghalaya relating to illegal mining of coal in the state. As per report, the government is now seeking legal opinion before filing a petition in the High Court seeking termination of his services. So it seems that the unwavering determination of the judge to expose unauthorized coal mining was the main cause that the people in power and the coal mafias in the state are too uncomfortable. So it was also reported that ever since he was appointed in April 2022, Justice Katakey has submitted over 24 interim reports, which confirms that illegal coal mining and transportation have been going on in various parts of the state. So this is not the first time that this kind of interference is taking place in the state of Meghalaya. It has happened before. Lokayukta officers were dismissed on flimsy grounds only for performing their duties, sir. We are made to believe that the findings of Justice Katakey may expose the entire connivance between men in power and the coal mafia on the state, sir. So the best thing is to remove this Justice retired Katakey. So we would like to express in this August House that as a party, we will oppose this move, this intention of the government. And we would strongly urge the government to not interfere with his performance and perhaps allow him to carry out his duties and responsibilities mandated to him according to this committee appointed by the High Court. So, sir, these are the few concerns only that I would like to raise as far as the law department is concerned. So with these few words, sir, I resume my seat.
Any member who wish to participate? I will now call the Minister in charge to reply, please.
Honorable Speaker, sir, I thank the Honorable Member from Nongkrem who has raised this cut motion, giving me an opportunity, sir, to discuss the style and functioning of the Law Department. Sir, having raised this cut motion and having raised one or two very important concerns of the Honorable Member, I would like now, sir, to explain what are the functions, what is it that we do in the Law Department. And at the end of this debate, sir, I hope that I shall be able to have done justice to the concerns raised by the Honorable Member. Sir, the Department of Law is an important segment of the Government of Meghalaya. Sir, the Department is also vested with the responsibility of preparation of panels of advocates in respect of the High Court of Meghalaya, the district courts, the appointment of advocates of panel to defend the interest of the departments of the Government of Meghalaya. So the department, in the capacity of administrative department of the district courts, is also engaged in the supervision and monitoring of execution of the CSS projects in respect of district courts, which includes the construction of the district courts, the subdivisional court buildings at different places, as well as the scheme for getting the establishment of special courts. So the department is also entrusted with the administration of public prosecutors, including additional public prosecutors, assistant public prosecutors, in the matter of grant of retainer, feeship, to standing counsels, both in the civil and the criminal, as well as paying remuneration to the additional PPs and reviewing their fee structure from time to time. The amicus curiae appointed by the various courts are also entitled to receive payments as per rules from the department. So the business under the law department include administration of justice, appeals against acquittals, law reforms, advice on legal matter, appointment of judicial officers, criminal and civil laws and its procedure, law officers, supervision of government litigation, drafting of bills and statutory rules and orders, appointment of all of these public prosecutors, additional prosecutors, government pleaders, assistant government pleaders, and the engagement of government counsels in the Supreme Court and the High Court. We have two wings of the law department, sir. We have Law B department. This wing of the department is primarily responsible for rendering legal aid services in respect to various matters of law referred to by various departments of Government of Meghalaya. It also undertakes various other functions having legal bearing, such as vetting of various statutes, rules, regulations, bylaws, notification under various statutes as referred to by the various departments of government of Meghalaya. It also examines cases with regard to desirability of filing appeals, revisions in higher judicial forums, besides appealing against acquittals as referred to by the departments of the government. This wing also deals with the drafting, the vetting of legislative proposals, bills, and also tenders advice on legislative business. It also takes stock of all kinds of acts in the original being implemented by various departments of the state. So, Law Aid Department deals with the administration of justice pertaining to the subordinate courts, which includes grants of administrative approval, expenditure sanctioned to CSS projects, and other schemes. So, under the CSS, the major project at present being executed is construction of district courts and subdivisional courts along with residential quarters. Till date, sir, 120 CSS projects are being implemented for the infrastructure development of judiciary at the total cost of 480.41 crores, out of which CSS released amounts to rupees 177.86 crores and 10% state share being 19.76, which has been utilized. An additional amount of 105.94 CSS and 11.77 crores is required for executing all the aforesaid infrastructural projects of the judiciary. In the current year, sir, the state government has been able to utilize 37 crores 76 lakh 66,665 inclusive of the 90% centrally sponsored schemes out of a mandatory 16 crores earmarked for release for the state, indicating the state's prioritizing the development of judicial infrastructure. So we agree in total with the honorable member that we need to ensure that the administration of justice occurs. And hence, we have special courts. One of such special courts is what we call the fast track courts. And this special court of the fast track court has been mandated by the POCSO Act with CSS funding. 5 POCSO special courts have been established in Shillong and 1 each in Nongpoh, Jowai, Nongstoin. Under centrally sponsored scheme for the fast track courts, the state has sanctioned a total of 6 crores 11 lakhs 55,223 from 2020-2024, being 5 crores 47 lakhs 89,750 under the central share and rupees 68 lakhs 65,473 under the state share. Other major projects under the state scheme undertaken was the construction of the High Court of Meghalaya and the ADR and mediation centers at Shillong and Tura. New projects are being undertaken under the state scheme, which includes construction of the permanent campus of the NLU, the MEG and ADR and mediation center in remaining districts. For effectively defending the interest of the government, the department undertakes an exercise periodically to prepare panel of advocates in respect of High Court and district courts. Those applicants who fulfill the requirements as laid down under CRPC and BNSS are considered for empanelment. Sir, the selection of the AG of the state is not on whimsical grounds. There are procedures indicated, there are qualifications indicated, and it would be a distraction to state that other parameters of judgment have influenced the government to select representatives that are important as the AG, the double AG, and the other members of lawyers that continue not only to defend the government but also to defend the common man. So we have what we call the Meghalaya Legal Service Authority. Meghalaya Legal Service Authority is functioning under the Legal Services Act 1987 as amended. Its primary job is to render legal aid, legal assistance to the weaker sections, downtrodden, SC/ST women who are unable to afford costs of engaging legal counsels, for speedy redressals of the disputes relating to variety of issues including the minor accident claim tribunal, the family disputes and others. This authority organizes loc adalats for resolution of such disputes expeditiously. The authority also conducts mega camps throughout the state to disseminate information on various central and state schemes being implemented by the government and educate and assist the masses on availing the benefits of all such schemes. So the Honorable Chief Justice of the Honorable High Court of Meghalaya is patron-in-chief of the authority and monitoring the functioning of the authority. Hence, I speak with confidence that it is the primary responsibility of the department to defend the have-nots and the less privileged. And we are continuously doing it through various schemes that we have. So we have the modified scheme of 2020, the Legal Aid Defense Council scheme. Whole documentation is here and we are trying our best, sir, to ensure that we perform our duties and fulfill our objectives. Sir, the main objective of the Legal Aid Defense Council is to provide qualitative and competent legal services in criminal matters to all eligible persons, to manage and implement legal aid systems in professional manner in all criminal matters. So we have a scope of work that is also designed so that we are constantly guided and we are constantly made aware of the responsibilities of the Department of Law to execute and to ensure that we are there. So we also have various committees at various levels at the district as well as at the state level. And each of these councils are guided by proper policy and principles. And we are trying our best. I repeat again, the fast-track special courts are also periodically reviewing the kind of administration of justice and ensuring that justice is not denied to the public at large. Article 39A of the Constitution of India also provides for equal justice and free legal aid. And the state is committed to secure that the operation of the legal systems promote justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disability. Sir, we have the State Legal Service Authority in our High Court, and we ensure that all of the schemes within this are administered and within the reach of the public at large. So on the matter of Justice B.K. Katakey, sir, the Honorable Retired Justice heading this committee has been appointed by the Honorable High Court, and it is not within my mandate nor the mandate of the state government to discuss this matter as it is sub judice. So there are fees, there are OMs, there are procedures that are laid down very clearly. I would like to appeal to the Honorable Member not to be disheartened and to have this impression, nor promote an impression that government is sleeping idle. It is not true that we are losing all of our cases. It is not true, sir. And yes, despite the complexities of the defense systems ingrained in the Constitution, and we will try our best to ensure that justice is there for all. Therefore, having attempted to a large extent to explain and defend the inherent doubting in the manner in which the cut motion has been put forward, I request the honourable member to kindly withdraw his cut motion so that we may be given the opportunity, noting, sir, that there are shortcomings in the law department. We have taken note of all of his observations. We will verify the extent of this of the occurrences of such lapses. And we assure the honourable member that we will do everything to ensure that justice is not denied to the common man, at the same time protecting the interest of the state government in all of its efforts to serve the people of the state of Meghalaya. With these few observations, I reiterate, I kindly request the honourable member to withdraw his cut motion, sir, and I resume my seat.
Thank you. Now, may I know the mind of the mover as to whether or not,
which also involves the provision of Rule 158, to somehow perceive the submission of the honourable members in this August House pertaining to any areas of concern cannot be referred to as inherent doubt. Inherent is something, inherent doubt means the member has that inherently, that habit of doubting. So I think that's not an appropriate word to be utilized to refer to a member of this August House, Mr. Speaker, sir. Through you, Mr. Speaker, sir, I will submit before this August House. We always avoid this type of words in this August House. The member who has moved this cut motion, to refer to him as a person having an inherent doubt, I think it must be avoided.
now may I know the mind of the mover as to whether or not he will withdraw his cut motion?
So, I am thankful for the positive response of the Minister. However, sir, as mentioned by the LO, Honorable LO, we would not expect that not only once, that there is always a perception on the ruling side that whatever we raise because of the doubts, of the misconception. So it would be appropriate, therefore, for the minister concerned to avoid using that words. And may I request you, sir, to expunge that words. So, sir, before I withdraw, I just need one clarification from the minister. Honorable Minister, steps taken by the government to ensure that people get easy access to these services. Because I feel that government needs to simplify the approach or the method where people can easily get access to these services.
So, various schemes have various provisions. In the POCSO Act, there are a set of procedures to access legal aid, and all of those, sir, go to a committee. The committee reviews, and the committee then assigns the prosecutors to assist the public. Sir, we also have, like I said, the Legal Aid Defense Council scheme. And in this scheme, sir, we have a scope of work. And in this scope of work, sir, we ensure that panels of lawyers are already paid for the representation of the public. Sir, we also have family courts, and in the family court also, women who approach these family courts are given a particular procedure to follow to access this legal aid. And so all of these are as per procedures laid down. It would take a lot of time for me to elucidate and to explain all of these various procedures. But I can assure the honorable member that maybe we need to have more awareness programs. In fact, the department also, through these various councils and various committees, are trying to make the public aware. And we have CAMs, we have all of these efforts that are put in so that we can ensure that every person in the state who requires legal aid should not be denied the legal aid. Thank you, sir.
If I can make a suggestion, sir, can the government have a helpline specifically for issues relating to legal matters, sir?
Point noted, sir.
Okay, sir. I would once again thank the minister, and I withdraw this cut motion.
Thank you. Since the mover has withdrawn his cut motion, now let me put the question before the House. The question is that grant number 4 be passed. Those who are for the motion say aye. Those who are against say no. The ayes have it, the ayes have it. The motion is carried and grant number 4 is passed.